Welcome to Opening the Door, Opportunities for U.S. Immigration with attorney Nadine Heights.
Hello and welcome to my podcast, Opening the Door, Opportunities for U.S. Immigration with me, Nadine Heights. I'm an immigration attorney in South Florida, and today I'm going to speak to you about a big decision that people often have to make if their immigration case is denied, and that's to appeal or not to appeal. And yes, that is a critical question. And it's something that I encounter frequently in my law practice. I often have clients come to me with decision denials and they're not sure what they should do. Do they have a right to appeal? Is it worth appealing? And what I also see frequently is clients coming to me who previously took matters into their own hands and, tried to appeal their case on their own and didn't get anywhere with it because maybe there was no basis for appeal. So basically, they just wasted their money. And I'm going to explain to you some examples of when you should appeal and when you should not appeal. So first of all, I'm specifically talking about appeals to the agency called USCIS, which is United States Citizenship and Immigration Services. I'm not going to get into immigration court appeals here, which is, deportation orders, removal orders, because that's a whole other topic. So I'm going to talk to you about USCIS appeals. So this could be for a green card case, which is probably one of the most common things I see, or maybe a naturalization case that was denied, someone who wanted to become a citizen. So talking about USCIS appeals, first of all, they're not even really called appeals. The form that you would use to, I use the form appeal because it's easily understood. But the form that you use, which is the I-290B application form, is actually called a motion to reopen and reconsider. So what you're doing is you're asking USCIS to reopen your case and reconsider it. And reopening is a little bit different from reconsidering. That's getting a bit more technical into the legal jargon. I'm not going to go into too much detail on that. But I think you get the idea that, basically you're trying to get another chance, right? You've got this denial. It was probably mailed to you, and it says your green card case is denied. And it'll often say at the very end of your decision letter, you have 30 days in which to, appeal this decision by filing form I-290B. It'll often say that. So that 30 days is important. And it's also important to understand that if the decision letter was mailed to you, which it most commonly is, you actually have 33 days, even though sometimes they don't tell you that in the letter. And that can be critically important when you're in a time constraint where you have to file something within a certain period of time. And you also need to understand that that appeal request or, motion to reopen and reconsider has to be received by USCIS within the required time frame of the 33 days. So don't think that you can post mark it on the final day. It has to get there. So what we do is we make sure to calendar this and we watch the days to make sure that we either FedEx it or get it there quickly if we're running into a time constraint, okay? So that's one important consideration. Now, what reasons are there to file this type of motion to reopen? Well, I'm going to give you some ideas and some examples of when you can file this type of appeal. And what's important to understand is that there has to be a basis for it, okay? So for example, let's say that you got a denial because you failed to appear for an interview with USCIS. Meanwhile, you didn't even know you had an interview, and this happens more frequently than you might think. Mail does go astray, right? Perhaps you moved and you legitimately changed your address with USCIS, but perhaps they still mailed your interview letter to the wrong address. They don't mail you twice. They send it to you. They give you maybe a month's notice. And if you don't get your interview letter and you don't show up, well, too bad for you. Nobody's going to remind you of it unless, of course, you have an attorney. And if your attorney filed your case, then your attorney will get a copy of everything that you get. And we remind our clients of their interview appointments. We make sure they go. We make sure that I go with them. So let's say you did your case on your own. You didn't even know you had an interview. Now, if you have a good reason for that, then you could file a motion to reopen the case because you want to explain what happened. You want to show evidence that you did submit a change of address timely. You want to make sure you have a copy of the change of address you submitted with USCIS, whether it's online, whether you called them. Everything has to be proven. Maybe there was a problem with your mail delivery. I mean, any evidence that you can provide is going to be required, okay? And you want to make sure that the evidence is acceptable and makes sense and is reasonable. And there is a provision in the law that says if you're actually filing this appeal late, you maybe still could have them consider it. However, you have to have a really, really good reason. So let's say you're just a week after the 33 days ran out and you just now found out that you had this interview. Who knows what the situation could be? But bottom line is you have to show that if you are going to be a bit late, you realize that you're taking your chances here because they could just outright deny you for filing the appeal late, which I see frequently. And don't forget, there's a filing fee with this appeal. Right now, the fee is $675 to USCIS just for asking them to reopen a case where they may have made a mistake. But unfortunately, it is what it is. Now, here's another example. Maybe USCIS made a mistake in the denial because you sent them a document that they asked for, but they denied your case because they said you never sent the document. So again, you have to prove you sent it. Everything you send to USCIS, be sure to keep copies, be sure to keep tracking receipts. Know that it got there on a certain day. Again, if you have an attorney, then we will make sure to track everything and keep copies of everything. So maybe you have a legitimate reason in that sense that they actually made a mistake. Or maybe USCIS applied the law incorrectly. Maybe you did qualify for an immigration benefit and they're telling you you don't qualify for a certain reason. And you know that the law is on your side, that you do qualify. And again, that's something you're going to need your immigration attorney to work on because that's what we do. We know what the law is and we know whether you have a basis for an appeal. So it's critical to understand when you can appeal or reopen a decision. Now, here's some examples of why you should not ask to reopen a case or appeal. Now, what can you do in the alternative is you could just refile your whole case all over again, which is probably going to be better than trying to appeal a decision where you just don't like what the officer said. And keep in mind, the immigration officer has a lot of discretion in denying a case. So let's say it's a marriage green card case and you provided evidence that you're living together with your spouse and they felt like you just didn't provide enough. I see denials like that sometimes that come across my desk. People come to me and say, look, I was denied of this because I didn't prove that, my spouse and I live together. And I look at it and I say, well, yeah, you hardly provided any proof that you're living together. So they use their discretion to deny your case. And that's not something you should ask to appeal or reopen because you would really just be wasting your money on that because they're just going to turn around and say, sorry, this is our discretion. We have the ability to deny this because we feel you didn't prove that you have a bona fide marriage. So That's not something you should appeal. You'll be wasting your filing fee money, wasting your time waiting on that decision. In that case, consult with an immigration attorney again, because it does get tricky. And if your immigration attorney recommends that you can refile, then we will refile your case and, get it approved the right way by submitting the right evidence. Here's another example why you should not request to appeal. Maybe you're filing this appeal really late and you have no reasonable excuse. I see that happening, believe it or not. People don't pay attention to the dates and they think that several months later, I've seen some 6 months later, appeals filed and no reasonable explanation why it's so late. You're just asking for a denial there. So those are some examples, and I want to touch briefly on a citizenship denial because it does involve a different process. The request to become a naturalized citizen, if you get denied for that, you're not going to appeal that. You're going to instead file a form called the N336, which is requesting a new hearing about your naturalization denial. And the reason for that is you can have a second chance if there is something that they did wrong, right? You can't just appeal on discretion, but if you do have a denial, bring it to an immigration attorney, bring it to me, and I will review it with you, and I will give you my advice on whether I think you qualify to get this hearing and to be able to then attend a second interview. So when you file this N336 form, you are requesting a second chance to bring in perhaps the evidence to prove that they made a mistake. I've had some of these decisions reversed because, sometimes you realize that this is a true mistake that USCIS made. And then what we do is we go back again for this second interview and we address the issues that we raised. And again, please be sure to consult with an immigration attorney. This is what I do. I want to make sure that you are going to get your case approved, and I will be able to let you know what I recommend, whether I recommend that you ask to reopen the case, or maybe we just have to refile it. With citizenships, sometimes we have to refile them a little bit later if there's a timing issue, and it can get really, really complicated. So please reach out to me if you have a denial or you know someone who has a denial. Contact us 561-290-0101 and book a consultation. All right, talk to you again soon.
Thanks for listening. For more information, go to heightsimmigrationlaw.com.